An urgent warning. The Supreme Court has shattered decades of established legal precedent, fundamentally altering the landscape of firearm rights across the nation. This isn't merely a shift in policy. It is a seismic legal event that has placed every restrictive carry permit system in America on borrowed time. The immediate threat is real, far-reaching, and demands your full attention. To understand why this legal earthquake occurred, we must examine the audacious tactics deployed by states like Hawaii following the Bruen ruling. The Supreme Court made it unequivocally clear. States could no longer hide behind subjective may-issue permit systems. Yet Hawaii, along with California, New York, New Jersey, and Maryland, defied this mandate. They didn't eliminate permits. They reinforced them, designing new restrictions intended to circumvent, rather than comply with, the Bruen decision. Hawaii's strategy was particularly aggressive. They inverted the very meaning of public carry, establishing a rule that declared, you could only carry on private property if the owner granted explicit advance permission. No sign, no prior approval, and you were automatically in violation of the law. This wasn't merely a disagreement over fees or training rules. It was a state transforming the entire core of a fundamental right into a permission-based system. This was the precise opposite of what Bruen affirmed, and it constituted a direct challenge to the Supreme Court's authority. This legal maneuver created a circuit split, with the Ninth Circuit upholding Hawaii's defiant stance, while other circuits, like the Second, recognized the inherent conflict with Bruen. The Department of Justice, usually a staunch defender of state-level restrictions, notably declined to support Hawaii's position. Instead, the DOJ acknowledged that Hawaii's ask permission or you're banned rule was indefensible under Bruen. They went further, formally requesting to participate in oral arguments on the side of the challengers, a highly unusual move for the federal government. This sent an unmistakable message that reverberated through every courtroom in America. Further amplifying this legal and political show of force, 26 states filed briefs supporting the challengers, arguing Hawaii's model was unconstitutional and a threat to national consistency. The legal battlefield had shifted overnight. States with restrictive permit systems were now outnumbered and on the defensive. At the heart of this confrontation lies one deceptively simple maneuver: Hawaii's attempt to redefine the concept of permission itself. Traditionally, the right to carry was understood as existing unless a property owner explicitly prohibited it. Hawaii reversed this, mandating that you could not carry unless explicit approval was granted. This transformed the Second Amendment into a mere permission slip, treating adults like children who must ask, "Mother, may I?" before exercising a fundamental right. This reverse Bruen approach, where a ban became the default, with a wall of silence to overcome for those seeking to carry, was precisely what the Bruen decision sought to prevent. The Ninth Circuit's strained attempt to validate this framework, stretching historical analogies beyond recognition, set off alarm bells nationwide. If Hawaii could redefine the starting point of a constitutional right, what would prevent any other state from quietly erasing carry rights through similar permission games? The Supreme Court is now tasked with determining whether the Constitution permits such an end run around a fundamental right. The Ninth Circuit's decision, upholding Hawaii's permission-first system, did not merely stretch Bruen, it effectively tried to fold it into origami. Bruen established a clear framework. The right to carry exists, and the government bears the burden of proving a restriction aligns with historical tradition. The Ninth Circuit, however, treated Bruen like a suggestion, turning the entire analysis into a hunt for vague historical analogies that bore little resemblance to Hawaii's modern law. Crucially, this ruling created a direct conflict with the Second Circuit, which had previously rejected similar permission-based systems. Such a stark disagreement between federal appeals courts on a constitutional issue is precisely the kind of split the Supreme Court cannot ignore. It means the Constitution operates differently depending on geographical location, an untenable position. The Supreme Court did not take this case because it wanted to. It took it because it was compelled to resolve this fundamental inconsistency. The repercussions of this ruling extend far beyond Hawaii's shores. If the Supreme Court strikes down Hawaii's permit model, the impact will cascade across the entire country, dismantling similar systems in states like California, New York, New Jersey, Maryland, and Illinois. These states adopted almost identical restrictive structures, gambling that collective action would insulate them from individual legal challenges. If Hawaii loses, their collective shield dissipates instantly. This creates immense legal and financial liability. Dozens of lawsuits are currently paused in lower courts, awaiting this Supreme Court decision. The moment a ruling lands, every one of those cases will reactivate simultaneously. States that have intentionally buried carry rights under layers of restrictions will suddenly face the daunting task of defending laws that are already legally precarious. This is not a gradual process. It is a rapid, legal unraveling. States, watching Hawaii, know precisely where they stand in this line of falling dominoes. Once the ruling hits, law enforcement will be the first to feel the shockwaves. Overnight, police departments will find themselves caught between an old permit system, enforced for decades, and a new reality where those permits may hold no legal weight. Some sheriffs have already declared permit checks moot. Others continue enforcement out of habit, fearing personal liability for making the wrong call. Prosecutors in multiple states have quietly begun dropping permit violation cases, not out of agreement with the ruling, but to avoid being sued for enforcing potentially unconstitutional laws. While officers scramble to understand the new rules, gun control organizations will enter full panic mode. Their entire playbook relies on permits, delays, and administrative hurdles. That structure now has profound, undeniable cracks. Police are in limbo, activists are scrambling, and the system's inherent fragility has been exposed. Beyond the legal challenges and enforcement chaos, there is a significant financial fallout that most are overlooking, but every state accountant is acutely aware of. Permit systems were not just regulatory tools, they were robust revenue engines. Application fees, renewals, mandatory classes, certification programs, background check surcharges all contributed millions of dollars annually to state coffers. Overnight, those revenue streams are beginning to evaporate. States that relied on permit revenue to fund administrative offices are now confronting an uncertain future for those departments. Some are not waiting for definitive answers, already canceling scheduled training sessions and processing refunds for unused fees. The shock extends beyond government budgets to private instructors, certification companies, and state-approved training contractors. Many built their entire business models around mandatory courses that are now legally questionable or entirely optional. The old system fostered a small, interconnected economy, and this ruling has exposed its extreme fragility. What replaces it remains unclear, but one truth is undeniable. The era of charging citizens for permission slips to exercise a constitutional right is rapidly concluding. This ruling is not an isolated event. It is the latest critical link in a chain of Second Amendment jurisprudence the Supreme Court has been forging for nearly 2 decades. It began with Heller in 2008, which affirmed the Second Amendment as an individual right. McDonald, in 2010, incorporated that right against the states, preventing local governments from creating their own versions of the Constitution. Bruen, in 2022, established the historical tradition test. Modern gun laws must align with America's historical tradition to be constitutional. This new decision is the logical, inevitable next step, answering a question the previous rulings did not fully settle. Do rights begin with government approval, or must the government justify every limit it attempts to impose? The court has now definitively closed that gap. For too long, permits were treated as a gateway to a right. This ruling has snapped that gate off its hinges. If Heller recognized the right, McDonald spread it, and Bruen clarified it. This decision emphatically enforces it. Once the dust settles, the inevitable question arises. What does a permitless America truly look like? The transition will not occur in a single dramatic moment, but will unfold state by state, policy by policy. Some states will rapidly update their statutes, having no legal ground to stall. Others will attempt to delay, inventing new requirements that resemble permits without using the word. However, the legal landscape has fundamentally changed, and courts will grant little latitude for creative detours. We will witness faster lawsuits, mounting pressure on states with stringent systems, and a nationwide drive to align local rules with the court's new standard. Training will shift from government mandates to voluntary education. The entire concept of proving eligibility before exercising a right is rapidly fading. The path ahead may not be a straight line, but the direction is unmistakable. The country is moving towards a world where the right to carry does not begin at a counter, a classroom, or a filing window. It begins with the citizen. With all the excitement and panic surrounding this ruling, many are asking, are firearm permits truly disappearing by 2026? The honest answer is this. The ruling has shattered the legal foundation upon which permits have stood for decades. However, the practical rollout will not hit every state at the same speed. Some states are already treating permits as optional. Others are rewriting laws to preempt incoming lawsuits. A few are still digging in their heels, hoping the storm will pass. It will not. The critical difference heading into 2026 is that the burden of proof has flipped. States can no longer defend permit systems by asserting, "This is how we have always done it." Now, they must justify every rule under a historical test that grows sharper with every case that reaches the courts. This means long lines, high fees, and subjective approvals are now legally unstable. Are permits ending overnight? No. Are they on the clock? Absolutely. And that clock is ticking louder every month. So this is where we stand. A Supreme Court ready to redraw the rules, states scrambling to keep up, and a permit system that is rapidly running out of excuses. The next moves will not be subtle, and they will not be slow. They will decide what you can carry, where you can carry it, and whether permission slips become relics of the past or rise back from the dead in a new disguise. If you want the truth before the headlines twist it, if you want updates without the noise, and if you want to understand these rulings before they hit your doorstep, stay with this channel. And trust me, what comes next is bigger than anything we have covered today.